Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, and thank you for joining us for the November version of the 12 Points Wealth webinar for essential legal documents that every family needs. We still have some more folks that are rolling through here. We're going to give them just another minute or two, and we'll get going. So thank you all that are on the line here. We'll get going momentarily, but we'll just give the other folks that signed up another minute or two. Thank you very much. Okay, Andrew, so we've got a good amount of folks here now. I think we're ready to start. So thank you all again for joining us. I'm going to take a moment to introduce myself here, assuming I can get this slide to advance. There we go. Hello, everyone. Christopher Cahill, partner here at 12 Points Wealth in Concord, Massachusetts. I'm an attorney and certified financial planner and chartered advisor in philanthropy, and a partner in charge of the Family Office Services Group at 12 Points. I have a particular expertise and affinity in the world of estate and trust planning, having practiced a number of years in that area. I work with primarily partners at major law firms, business owners, and other wealthy families to achieve their financial objectives, identify what they are, and help them through all facets of their wealth management and legacy planning. I'm really, really excited to have with us today my good friend and colleague, Andrew Butler. Andrew, why don't you give everybody a little overview as to your background here?
Sure, Chris, and thank you for having me today. So as it shows here on the slide, I'm Andrew Butler. I'm an attorney with Archstone Law Group, which is based in Newton, Massachusetts. I've been in practice over 25 years, I think coming up on 30 next year. And early on in my career, I worked some of the big firms in Boston. I've been sort of out in the burbs for about the past 20 years. But throughout all of my time as an attorney, I've focused on estate planning, estate and trust administration, and some elder law as well. And I work with individuals, couples, families, and help them set up estate plans and make sure that they stay up to date.
Wonderful, thank you, and we really appreciate you joining us here again today. I know that you and I did this same presentation a year ago, but very, very timely, I would say, because we're talking about planning. And I think you would agree with me that it's always a good time to plan, but people tend to like to plan around year end for some reason, like to kind of check things off of their list, so to speak. So never a better time than now to start talking about this stuff, right?
Exactly. Maybe one less thing to put on that New Year's resolution list. So you can take care before year end. So or at least get a jump start on it before the new year.
That's right. So today we're going to be talking about the basic estate planning documents that every family needs. We will talk a little bit about some potential changes in tax laws going forward, maybe a little bit more higher end documents, if you will, rather than just the basics that we're going to cover here too. But really this is kind of a 101 sort of presentation on estate planning, and topics that we're going to cover for certain will include wills, living and revocable trusts, powers of attorney, advanced medical directives and healthcare proxies, Hipaa authorizations, and irrevocable trusts. Now, I think it's important for us to talk about this just at the very beginning, that, Andrew and I are both licensed attorneys in Massachusetts, and we're located here in Massachusetts. I also know that there are folks on this line that are likely in other jurisdictions. I'm certain there's two friends of mine down in Texas that are on this line. So just know that we're going to keep it high level, try to avoid as much specificity with regard to state law as we can, but nonetheless know that you would be needing to work with a licensed attorney in your jurisdiction, whatever state you happen to be in, just for consistency and thoughtful planning purposes. So with that being said, Andrew, why don't we talk about wills? Explain to us what a will is.
Right. So, so what a will is, it's probably if you ask somebody, what's an example of an estate planning document, it's probably at the top of most people's list. I think it's probably what they've heard they'd heard that term the most. But what a will is a testamentary document, which means it takes effect at someone's death. And it generally does, I would say, three things. One is it provides for the disposition of probate assets, and I'll expand on that in just a second. It's also where you name a representative of your estate. In some jurisdictions, that person is called an executor. Here in Massachusetts and a number of other states, that person is called the personal representative. So it's someone who can act on behalf of the estate. And finally, for people who have minor children, it's the document where you name a guardian or guardian for them in case something happens to you before they reach the age of majority, which again, here, at least in Massachusetts, is age 18. So, if you don't have minor children, that piece doesn't apply. And this is an important point, if you don't have any probate assets, you should still have a will, but there's a good chance that you won't need it. And that's sort of the idea of avoiding probate, that if you don't have any probate assets, then there's no need to do a probate.
Real quickly, how would
go ahead, Chris.
How would one not have probate assets? What sorts of things could you do
right
in a small world to avoid that?
Sure. So a few things. One is just simply the nature of the asset. So life insurance policies, retirement accounts, whether they be IRA, 401k, 403b, et cetera, those pass based on the beneficiary designation, not based on what you've put in a will. So as long as you've named the beneficiary for those retirement accounts or life insurance policies, that's who it will go to outside of the probate process. Okay. Also, assets that are jointly owned. So I work with a lot of couples where they own at least their primary residence in joint names. Something happens to one of them, the title to that home will automatically pass to the survivor. That would also be the case with a joint bank account or a joint non-retirement investment account. The other strategies aren't based on simply the nature of the asset, but actually the way it's titled. So a couple of things. One, and I think we're going to get to this next. You can create a revocable or living trust during your lifetime and retitle, whether it's a piece of property, a bank account, investment account, in the name of that trust. That's one technique. Another way, this is sort of similar to utilizing a beneficiary designation, but just for accounts where that terminology doesn't apply. For a bank account, you could add what's called a POD, or payable on death provision, instructing the bank who to pay the account to at your death. Or similarly, on an non-retirement investment account, you could add a TOD, or transfer on death provision. So those are various ways to sort of avoid probate. I always tell clients, though, even if you don't think you have any probate assets, you need to have a will, because invariably there's something that people forget about, and we don't want to kind of have that sort of fall between the cracks.
Wonderful. No, the great point, great observations. And I think it bears stating here that as you just described, the many ways to avoid probate, and the reasons why one would do that is you want to minimize the cost and time and delay and publicity of all of that. But the reality is so there's a lot of ways to avoid it. But there's also a lot of ways to have an estate maybe not go the way you want it to, the distribution of the assets. And by that, I mean, if you had a will, so as you just described, that will being the linchpin for many estate plans that said all assets to one person or another, maybe your spouse, maybe your children, maybe your grandchildren or friends or whomever. If you didn't coordinate the other documents, your other assets with that will, you could end up with something totally unintended. Unintended.
Exactly.
So, you could have
Exactly.
the beneficiaries might end up, if you don't pay attention to them, my point being that you could end up in a situation where things really aren't what you planned. And I think it just bears repeating that it's good to revisit these documents regularly. I like to say 3 to 5 years, and certainly at life-changing times, marriage,
Mm-hmm.
new kids, grandkids, etc. So let's talk a little bit about living trusts.
Mm-hmm.
Tell us what one looks like, why you'd want to have one.
Sure. So yeah, I would say, the majority of people, it makes sense for, but it's certainly not 100%, despite, maybe ads you see or ads you hear on the radio or things you might get in the mail that might say that, everyone needs a living or revocable trust. But in most cases, it can be beneficial. And I would sort of put the benefits into, I would say probably 3 categories. So one we've already talked about, which is it's a one tool for avoiding probate, and kind of the extension of that is that it's also helpful during your lifetime. If there's an extended period of incapacity, it's helpful if someone can manage some of your assets. If they're in a trust, they can do that sort of in their role as trustee or successor trustee.
And I'll just interrupt on that point, Andrew, if you don't mind. That is
Mm-hmm.
such a huge benefit, and often overlooked plus and pro as it relates to these trusts. The reality is that for some reason, financial institutions and the general populace is totally fine dealing with a successor trustee on a trust. Happy to do it anytime, no problem, all good. If you walk in with the next document we're going to talk about, a power of attorney, it's like they throw the fire alarms and everybody's alerted, and all of a sudden they start coming out looking at it with the microscope, and it's just a different world. So you can avoid that scrutiny with these trusts. So sorry to interrupt, but I just felt that.
Yeah, no. I'm glad you emphasized that point, because I definitely have had that experience on far too many occasions. So again, sort of long-term management of assets during incapacity, probate avoidance, and then the other 2, main advantages of a living trust are, one is if you're in a state, and Massachusetts is one of them, that has its own estate tax. A living trust, and you're part of a married couple. It's really, if not the only, it's certainly the best way to take advantage of the state estate tax exemption, which again in Massachusetts is $1 million. Without that, it becomes very difficult, if not impossible, to at least shelter that first $1 million from the Massachusetts estate tax. Not as much of an issue on the federal side, because there's the concept of portability, which is sort of beyond the scope of the conversation today. But again, if you're in a state that has an estate tax, there aren't that many, but Massachusetts is one of them. The living trust is a way of at least sheltering that first $1 million from estate tax. And then the final, sort of primary, final main benefit of a living trust is if you want to leave assets to people and you're not comfortable with them gaining access immediately, like meaning that you don't want to just give it to them outright. They can do with it what they want. So, that could be, that you've got young children. It could be that you have adult children who have, some form of disability. Could be you have a concern about how someone might spend the money. I mean, it could be any number of reasons why you just don't want to give one or more of your beneficiaries immediate, sort of control over their share of the inheritance. So the trust can be designed in a way that it can, not pay out until the person reaches a certain age or certain milestones, whatever it may be. So, so I would say those are the main benefits. And as the slide points out, what's sort of the downside? Arguably, obviously, if you're doing something more than just a simple will, then it's a more complicated plan, and it'll be more expensive to set up. There aren't really ongoing costs with a trust, though, which is good. But the initial setup, that will cost you a little bit more. And then, the trust is only as good as sort of, your utilization of it. So, unless you, again, if one of the goals is probate avoidance or being able to control assets, someone be able to control assets as a successor trustee during lifetime, that can only happen if you fund the trust during your lifetime. So you might have spent some money, have this complicated, extra piece of your estate plan, but you're not getting the real benefit from it. So if you're going to make the investment, make sure you do the follow-up steps as well.
And I can't tell you how often I see clients come into my office that have spent lots and lots of money on trusts and estate plans, not Andrew's clients, mind you, but other attorneys' clients, where they've just signed the documents and walked out of the office, never to look at it again. And they didn't do this part of actually funding the trusts, and it's useless, as the slide says, and as Andrew indicated. So really important to follow up and fund, put all of the assets that you can into these trusts. That will help avoid the probate. It will help protect the assets, et cetera, as we just described. I would like to point out as well that one of the benefits that Andrew just described relative to the trusts of being able to keep assets in trust for your beneficiaries, whomever they be, maybe your children, your spouse, your grandchildren, your friends, or whomever. Huge issue, and something that I can't speak highly enough about is keeping the assets in trust for a long time. I often have clients that say, "Oh, my kids are good with money. I'm just going to give it to them outright at 25 or 30 or 35. I always push back on that. You never know what's going to happen. They could get in a car accident and be subject to a lawsuit. They could have a divorce. They could have if they're a physician or whomever, they could have a malpractice case. Any number of bad things that can happen. If the assets are distributed out to them, they're fair game. If the assets are held in trust with a discretionary trustee, it's a whole lot harder to get. So I tell all of my clients, put your trust in a trust. Keep the assets there as long as possible. I really believe in lifetime trusts, and I'm a huge fan of that. And I recognize some people say I don't want to rule from the grave, but I think that if you set it up correctly, administer it correctly, and explain to the beneficiaries why you're doing it. You're not doing it because you didn't trust them. You're not doing it because you don't love them. Point of fact, you're doing it because you do love them and you want the assets to be there for them. So moving forward, powers of attorney. We touched on this a moment ago. Why don't you take us through what a power of attorney is, Andrew, and what the strengths and weaknesses of them possibly could be?
Sure. Yeah, and just at the outset, I just want to say that sometimes there's confusion about power of attorney and a healthcare proxy or healthcare power of attorney. In Massachusetts, these are two very separate documents. So the power of attorney, and we often refer to it as a durable power of attorney, that designed to allow someone to take over your day-to-day sort of financial personal affairs during a period of incapacity, but specifically not to have any authority, no authority whatsoever regarding medical decisions on your behalf. That is exclusively falls, within the confines of the healthcare proxy, which we'll get to next, and the person serving there as your healthcare agent. So again, sometimes sort of people use these terms, these two documents kind of interchangeably, but they really are separate, similar, situation, period of incapacity, but they are, again, very, distinct documents. So again, I mentioned that we often refer to them as durable because normally a power of attorney, if I give you my power of attorney and then I become incapacitated, normally your authority would end, because if I'm incapacitated, in essence, I can no longer give you authority. You can no longer act on my behalf. So by statute, Massachusetts, and I think every other state in the country, adopted the concept of a durable power of attorney, and the durable part just means that it survives the principal's incapacity. Okay, so for our, you might have a non-durable power of attorney. You want somebody just to represent you at a real estate closing, something like that. Something kind of more limited. But for what we're talking about for estate planning purposes, what you want to make sure that you have a durable power of attorney. And I think that term, I think as far as I know, in every jurisdiction they use that same term. Okay. We usually set them up so that they take effect immediately. Now that might sound counterintuitive to some people. People might say, well, if it's designed to be used when I'm incapacitated, why do I want it to be effective right away? The feeling on that is that you want whoever you've named in it, you want them to be able to take charge, whether it's paying bills, filing tax returns, you want them to be able to do that right away. There might be things that need to get done on an urgent basis. If there's a requirement that of some proof of incapacity, that might take time. You've got to talk to the doctor. They may have to run it by their legal department, et cetera, et cetera. Meanwhile, the clock is ticking and things aren't getting done. So, my feeling is as long as you're naming someone you trust, and if you don't trust this person, you probably shouldn't be naming them. If you're naming someone you trust, then it's okay to have them have their authority technically kick in immediately when you sign the document, because the understanding is they're only actually going to exercise it when it's really necessary, which would be during a period when you mentally and or physically can't do these things yourself.
Perfect. So, excuse me. One of the things that we touched on a moment ago is the fact that for whatever reason, people are really afraid of utilizing powers of or accepting powers of attorney, and it escapes me why, but it never ceases to fail that if you're walking around with the power of attorney trying to move assets or do things on behalf of somebody that's incapacitated, they're going to bring out the legal squad and everybody's going to really get kind of crazy on you. So again, another reason to use the trust components and successor components in the living trust as much as you can.
No, for sure. But they're assets that just by their nature you can't get into the trust. So this power, the gold standard would be sort of a combination of creating a trust, funding it, but then also having this power of attorney is kind of a backup, and those two things can kind of work in conjunction.
Absolutely.
And then keeping the power of attorney up to date. One of the things I sometimes hear from institutions is that they'll say the power of attorney is too old, that it's stale. And there's no legal basis for them to say that, but they still do. And so if you can, even if you're not really changing anything substantively, just get a fresh date on this document, maybe every 3 to 5 years, so that at least that argument, they can't make that one on you. But I, Chris, I absolutely agree with you. I mean, for whatever reason, there just tends to be this pushback on powers of attorney. Not to the point where we shouldn't have them. People should absolutely have them, but just know that you might run into some issues. That's all.
There you go. So now we talked about the difference between the power of attorney and a healthcare proxy / living will here. Let's talk about this.
Yeah, and I know we got a couple more slides to get to, so I'll be brief on this. So one is, the healthcare proxy, this is something that everybody should have. It's what it's called here in Massachusetts. Other states use other names for it, but it's a document where you name someone to make medical decisions for you in the event you cannot communicate your wishes yourself. So unlike the power of attorney, which typically kicks in immediately, this clearly, no question on this at all, this only kicks in if there's a determination that by the physicians, nurses, et cetera, that you cannot express your wishes yourself. So they'll sort of discuss it and they will kind of invoke it. So you don't have the concern that somebody's going to be making medical decisions against your will. So the living will, advanced medical directive, this is at least in Massachusetts, not recognized by statute, so not legally enforceable, but this is basically a document that many people put together, and it basically gives the healthcare agent, the person serving in your healthcare proxy, it gives them parameters, guidelines, whatever you want to call it, in terms of what your wishes are. Because again, their job really is to carry out your wishes, not impose their own sort of feelings on it. And how do they know what you want? You need to tell them, and that could be here in writing. I personally am a strong advocate of talking to your healthcare agents about your wishes. I mean, I think you can only put so much in a black and white document. I think conversation, and really conversations over a period of time, really kind of supply sort of the color. So that the living will might be the black and white, but those conversations, which sometimes arise when someone else, some loved one is going through an illness, end of life type of scenario, and you might say, well, if this were me, I'd want this, I wouldn't want this, and that kind of gives that agent a lot more, sort of direction and guidance.
No better time of year to have those conversations than the holidays. I mean, you're going to be with your loved ones, you're going to be with the people that you've appointed. Certainly, I completely agree with Andrew that these are really important conversations, and no time like the present, truthfully. So in the interest of being expedient with our time and paying attention to your schedules, we're going to talk here just briefly about Hipaa. This is a law that allows you to appoint a individual to get access to your personally protected healthcare information. If you had given an agent a healthcare proxy, absent appointing them with HIPAA authorizations here, they're going to have a hard time making informed decisions because they don't have access to your medical record. So these things kind of go hand in glove and are really, really important. Sometimes you see them in the healthcare proxy itself. Sometimes they're separate documents, but know that very, very important.
Yeah.
So
I would agree.
So moving forward here, Andrew, let's talk about why you would want to have an irrevocable trust. We talked about those revocable trusts a minute ago. Let's talk about why you might want to make a trust irrevocable.
Right. So I talked a little bit earlier about the estate tax, state estate tax, also the federal estate tax, and what the estate tax is. It's a tax on assets that someone owns at the time of their death. So if you don't own them, then there's no tax on them. So putting them into a revocable or living trust, that doesn't change the ownership from a tax standpoint. So putting assets in a revocable trust, they're in there at your death, they're still going to be subject to estate tax. So that's not going to help you from an estate tax standpoint. An irrevocable trust, though, is different because in a situation like that, once you put them in there, you can't take them back yourself, and you also give up, control over them. So, but by giving up the access, the control, the access, that also takes it out of your estate. For people who, potentially have a significant estate tax, issue facing them, particularly if they might be subject to federal estate tax, which is the tax rate is 40%, and that historically has been as high as 55 or 60%. Getting assets out of the estate can be very powerful, and we could spend literally hours, if not days, talking about different types of irrevocable trusts, et cetera. But I think that the main reason we use them again is to try to reduce the estate tax bite. They're sometimes used in a long-term care planning setting. Someone who's maybe hoping to qualify for Medicaid, for Mass Health here in Massachusetts. I mentioned that again, we're trying to get assets out of the estate. I would say just two other quick points on irrevocable trust. So one is that I would say the asset that we most often put into these trusts are life insurance policies, because for the most part, you don't really care about owning the policy. You just want to know you've got the coverage, and if you die while the policy is in place, that the money is going to go to your family. So that's an easy asset to get rid of, because you're not going to miss it, because owning it doesn't really do anything for you. You just want to make sure you've got the policy. And the other thing I mentioned earlier is you've got to give up. You can't retain an interest in this irrevocable trust, but you can give your spouse, if you have a spouse, you can give your spouse an interest, which is arguably pretty close to keeping an interest yourself if you're on good terms with your spouse. Meaning you can put assets in the trust, and if you really need some of those back, even though the trust is irrevocable, a distribution could be made to your spouse, and then through the spouse, presumably you could kind of share in that. So those types of trusts, we use the acronym SLAT, Spousal Lifetime Access Trust, and it's a nice vehicle where you want to give it away, you're comfortable giving it away, but you just want to have a little bit of insurance that you really need some of it back. You've got a mechanism to get it back. Well said.
So, excuse me. I want to get to a question here that Ann had posted a moment ago. And it's a great question. So thanks, Ann. And sorry for my delay in seeing it. You'd asked, what do we mean by funding the trust? I think that's a great basic question. Let's talk about what it meant to fund those revocable trusts before we kind of move to wrapping this thing up, Andrew.
Yeah. So when we say funding a trust, we simply mean putting an asset into the name of a trust. So if it's an investment account, it would simply be instructing the financial advisor, the financial firm, that rather than having the individual's name on it, so instead of being in the name of Andrew Butler, it could be in the name of the Andrew Butler Revocable Trust, Andrew Butler Living Trust. That trust will use my Social Security number, so for tax reasons, nothing's changed. And the only difference I will notice is when I get my monthly statement, it'll be addressed to me as the trustee of my trust. But other than that, all the income, et cetera, will go right onto my tax return every year. And again, the difference will be when if I have a period of incapacity, the successor trustee can take that account over. At my death, that will already be in the trust. We won't have to go through the probate process. So bank account, same thing. You just tell the bank you want to just change the title on the account. Real estate, you'd have to record a deed. But pretty much anything other than a retirement account. I mean, you can't. Retirement accounts are not assignable. You can't put a retirement account into a trust. But again, you wouldn't want to anyway because it's not a probate asset anyway.
Mm-hmm. Excellent.
So hopefully that answers your question.
Yeah. Thanks so much, Andrew. Appreciate it. So as I said, we're just getting near the end of our time here today. So we're just going to talk briefly about prenuptial agreements before one gets married, well in advance of getting married, many months. If you have wealth and you're trying to protect it in the event of a potential divorce down the road, you might want to consider a prenuptial agreement. What we don't want to have is having somebody spring a prenup on their impending spouse the day before the wedding and say, sign this or we're not getting married. Duress is a bad thing, and courts will throw that document right out. So, a well thought out prenuptial agreement well in advance of the marriage is a great way to try and protect assets. You can divide them in advance. You can protect assets. You definitely need an attorney to draft it, and you definitely need to have full, open, and honest disclosure of assets. If you don't, you're putting yourself in a situation where you might think that you're protected when, in point of fact, you're not.
Yeah, what I say about prenuptial agreements is that it's very similar to if you were going into business with somebody. You and a partner were starting a business together, and you expect the business to be successful, be long lasting, but you'd have an agreement that would say, well, if we decide to not be in business anymore, sell the business, whatever, what would the terms of that be? And so it's the same idea. It's just saying, let's just ahead of time kind of figure out what would happen if we get divorced, so that we won't have that additional sort of stress, emotion, drama, whatever, of having to and expense, because contested divorce can be very expensive.
Sure.
Let's just figure it out ahead of time, so that if that happens, and not intending it for it to happen, but if that happens, we'll have already kind of figured it out, and we can just go with what the document said and then move on with our lives.
Absolutely. So as you see here on this slide, in essence, as Andrew described, it's going to help you with your division of assets. Oftentimes, people that bring up the idea of a prenup are not the two impending new spouses. It's one of them, or one of their parents, or both of their parents, as the case may be, that are trying to protect an inheritance. So clearly defining what an inheritance would look like, identifying spousal financial rights, and protecting yourself, honestly, if you have one spouse coming into the marriage that's got a significant amount of debt. These are things that you'd want to pay attention to. Certainly.
Yeah, another item we often will have some particular attention on in the prenuptial agreement is the home, particularly if one spouse sort of put most of the money into the home, and so there may be some kind of formula for if that home gets sold, divorce, whatever it may be, that there's some formula for how the proceeds get divided to take into account that it's starting off in a sort of a degree of unevenness.
Well said. And so we talked about prenuptial agreements. There are these things called post-nuptial agreements, often utilized. I shouldn't say often, can be utilized in certain circumstances and can provide some real great planning opportunities for couples trying to agree after a marriage and prevent issues down the road. So know that those are there, and things that you might want to contemplate in certain circumstances, a little bit beyond the scope of our presentation here today. But as we are trying to get to being under 45 minutes, here's my contact information. Chris Cahill, if you have any questions, you can certainly reach out and email me at chris@12pointswealth.com or chris@12points.com, and you'll see my phone number right there. Really appreciate all of you sticking with us here today. And most importantly, this is Andrew's contact information. And Andrew, I really appreciate your assistance here today, as always.
Yeah, no, thanks for putting this together, and thanks to everyone who attended today. It's not always the easiest topic, but clearly for everybody who attended today, they realized the importance of it. And we kind of skimmed the surface here. So if you have questions, you've got both my email and phone number there. Feel free to reach out. I'm always happy to answer questions and just sort of educate people on this. So
great, thanks, Andrew. And last word on this: these documents aren't just for you and your spouse. If you've got children that are cresting to young adulthood, in Massachusetts, as soon as they're 18 or older, you no longer have the ability as their parent to go into a doctor's office or a hospital and make medical decisions for them or deal with their finances. So making sure that your kids that are graduating high school and potentially going off to college, those young adults, have a basic will, and most importantly, that durable power of attorney and healthcare proxy and Hipaa authorization, really, 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 really critical today more than ever. So final words, get those documents for your kids. Thanks again, Andrew. Yeah. Appreciate it as always.
Thank you, Chris. And again, thanks to everyone on the call today.
Same. Bye-bye, everyone. Thank you.